who does a deep dive into official data and works with official data will reflect deeply on what are the challenges and the limitations of using such data. Vijay, with his extensive experience on prison-related work, will bring in that perspective that we haven't yet brought in over the last few sessions in terms of what do we need to know about prisons that we as of now just cannot know, and where do we need to go in terms of prisons data, and what do we need to know about prison conditions, incarceration, post-incarceration, all of those issues. And then Pooja will seek to disrupt things in the sense of asking us to think about why is the data the way it is in the Indian criminal justice system, and how should we look at this issue of data and seek to ask some difficult questions to make us introspect. So if we can just have the three of you on stage, please. Valay, Vijay and Pooja. As yesterday, I'll keep keep a 20-minute count, and I'll give you reminders at 10 minutes and 5 minutes, and when the time's up. 20 minutes, yeah. And I'll give you reminders at 10 and 5. We'll after they finish with the opening remarks, we'll have a discussion for about 15-20 minutes, break for a quick tea, and come back and resume that discussion. This is a session that runs from 10:30 to 1. All right. Valay, over to you.
Thank you, Anup. Just give me a moment. Okay. Good morning, everyone. Thanks for coming back in large numbers. We are going to talk about challenges with using official data. As India Justice Report, we deal with a set of data, not the entire universe. And my comments are based on the experiences with those sources, largely. I will also, for the benefit of those who are not aware of the India Justice Report, talk briefly about the Justice Report. Well, the India Justice Report is a collective of 6 organizations: the Common Cause, Center for Social Justice, TIS Prayas, Daksh, Vidhi, and How India Lives. And we started this project in 2018 to de-silo the data sets pertaining to police, prisons, judiciary, and legal aid. We also came up with a methodology that at that time was, we thought, a little too bold and courageous, which was to rank the states basis capacity. And since then, we've launched 3 reports. So what is firstly, I think we were talking about this a lot yesterday. What is data and what does the IGR consider data? So I think in the minds, data only means or mainly means numbers. And numbers tell a story, but they don't tell the entire story. And those who profess blind faith, blind love for numbers, may not be able to do justice to the issues that they are using those numbers to create awareness or to drive advocacy or to drive change. So firstly, I want to just make it clear that while IGR uses numbers, crunches numbers, it doesn't consider that alone to be data. What I think we are more concerned about all the time is information, it's knowledge, it's insight. And we use the numbers to strengthen those insights or to dispel, disprove, or to prove those insights and experiences. There is a limitation to it, and we can't do it all the time through numbers alone, and we do then put those caveats wherever necessary. Having said that, also want to acknowledge one more critical aspect, which is that the data as it exists across different systems pertaining to criminal justice may not be perfect, it may be far from perfect, but in terms of quantity, India produces far more data than many other developing countries, in fact, most other developing countries. And just the data on police organizations report alone, for example, puts out more than 105 tables. And that cover all aspects pertaining to police organizations. I'm not talking about crime in India because we don't feel comfortable taking those numbers and crafting very serious or narratives around it because of two reasons. One is the numbers themselves may not be fully reliable. And second is that this, I think we spoke about it yesterday, that data literacy is very poor, statistical understanding is very poor. So if we start using crime figures and get into the wrong sort of ideas of higher crime reporting is a bad thing and lower crime reporting is a good thing and all of that. So the IGR does not deal with crime in that sense. We do use it to mold our understanding. We do use it to, wherever we can use it in a defensible, justifiable, reasonable manner, we use it. Now, coming to slowly entering the topic. The challenges of official data. So we have found that neither is official a monolith, neither is, as I said, data is a monolith. When we talk about official data, while the IGR uses central repositories, sources, data sets, we have come to understand that central sources are often simply a collation of what has been put out by state governments, state systems. So there is that disaggregation that the BPRND and the NCRB may be putting out data, even e-courts is putting out data. Those data sets are collated, collected, maintained by state agencies, state governments, state departments, and so on. And what they report is what essentially makes to the central repositories. So that is one. And within this official data, it's again, we cannot say that it is very uniform. Some systems, subsystems are putting out better data, and others are not. And I am happy to take, name names in our discussion, but right now I'll just say that we cannot consider it a monolith. Some official systems produce better data, others are less meticulous. Some are more timely, others are not. So we cannot club it all together and say official data is great or official data is rotten. We will have to nuance our view, we feel, at IGR. And therefore, that point is the second last point of variation in accessibility. So right now we are doing an exercise through RTIs where we have filed over 500 RTIs to 4 different departments for each state government, asking them questions relating largely to the compliance of the Juvenile Justice Act. I think this input had come from Professor Ashwini Deshpande yesterday, that they did the similar exercise for COVID, and the postman wouldn't stop ringing the bell. Well, that is what you asked for. So if you've filed RTIs and the state agents are making that effort, the effort may not be up to the quality that you expect, but they are making that effort. And so we are getting details of yoga sessions conducted in a shelter home for children in a say, Chamoli district, some shelter home. We are getting that kind of granular data. It's not useful for our exercise. We are getting data, or information rather, that on Mental Health Day, we ask children to write an essay on mental health. So it is information. We as IJR may not be able to, and we don't want to convert it into a number. But I think that is the point also of this exercise, that we make our allies and we share with each other the information that we get. So I'll be, for example, very happy to share all that information once it is in a shareable form with Swagata and other colleagues who are working in child protection. Because it's a massive exercise, and we are going through it knowing very well that what we will finally get may not be something very useful. So that is just one example. Then I'm talking about the textures that exist in the data. And yeah, let me refer to some examples over here. What is also happening a lot is that NCRB and BPRND are changing categories under which information is being put out. I mean, not year on year, but every 2-3 years, few years, you'll see that they've changed the categories. For example, the disaggregated data of women in civil and district armed reserve police was available 1 year, was not available 1 year, on another year. Now, why does it make a difference? Well, largely we want to see more representation of gender in all categories of the government, including the police. There is the civil police, which is largely responsible for law and order duties that pertain to the everyday sort of policing work. And then there's the district armed police. Should we be taking a stand that no, okay, women can only be, it's better that they're only in civil police? And if they are not in enough numbers in district armed police, that's all right. If we do that as researchers, then that's our own bias. So why is the BPRND, for example, has it stopped putting out this category disaggregation? The most obvious one would be the data on religious minorities, which was collected and put out from 1999 to 2013. And since 2014, that data was stopped from being available online. So moving on to the next one, I think coming to the challenges. Yeah. There is a problem of trust. Do we trust the data that the government puts out? As IGR, I have to say, we do trust the data that we use. Otherwise, why should we be using it? And what we don't put out there is a reason for it. One of the reasons could be that we don't trust that data. We don't trust that data, especially relating to what could lead to heightened scrutiny, what could lead to contention, what could be an undesirable outcome for political masters. So there is a mistrust of certain data sets that are being put out officially. Then incompleteness I've referred to, that you put out only some type of data and you do not disaggregate it enough, which stops researchers or anybody who's interested in holding government to account in doing that. Then there is the problem of disappearing data. I referred to the minorities example, but let me refer to a more recent example, which is that in 2022, the parliament was told that there are X percentage of SC, ST, OBC judges in the subordinate lower judiciary. We used that data in our third report. It was very helpful. This year, that data has not been shared with Parliament. In fact, the reply has been that this is not maintained by us. So clearly, what could be maintained in 22 was probably not updated, or it was not put out. We don't know the reasons. We don't want to speculate. But this disappearing data is an issue that is kind of obvious. And if there are friends who are working with government, I hope we can have a good discussion around it. And maybe there are some things that we don't know and understand better, so then we like to do that. The standardizations, the double counting, the silo-ness of the data and the uncoordinated information often leads to real-life implications and consequences for people. We hear of stories of prisoners languishing in jails because their orders have not reached, or they were wrongly categorized, or I actually want to talk about also a larger issue that do we even have a data policy just pertaining to the criminal justice system in the country? And that is not just outward looking, but it is also inward looking. For example, the government, probably most governments do not know what are the working hours of their own staff. How much pressure are they under? What is the workload of an IO in their state? Why, and should this information not be systematically maintained as a feedback loop? So it's not just about, okay, people like IJR wanting to get more disaggregated information, but it's also about governments using that feedback loop to improve their own functioning. Yeah. Yeah, no, I'm good. This slide that you see is a good example that here on the left is the cases registered against state police personnel for human rights violations in 2022. And you can just look at that beautiful set of zeros and ones or twos. On the other hand, is the number of custodial death and rape cases. This is another data set, which is probably closer to the truth. So within official data sources also, there's a huge discrepancy, which is a cause of concern, and which, frankly, unless there is a increased public conversation around these data practices, it is not going to change overnight. I don't think it is up to just researchers. It's about making this conversation around justice delivery a public conversation, which is why IGR used the tool of ranking, which is why IGR crunches over more than 1 lakh data points into 100 indicators so that it can be digested and understood in a simple way. And what we do this by using states' own data, holding them to their own benchmarks, and putting out nuggets like this. So what do we spend on inmates per day, just on food? A lot of the people out there might say, even this is a lot for prisoners, because they've already judged them. We crunch it to say, if you've bought a toffee today, that's more than what is being spent on your protection of your own human rights by state human rights commissions or by the National Human Rights Commission. If you have bought 3 burgers now and you plan to eat 2 more later, then you've spent the money that is going to be spent on policing in the entire year on you. So what is out there is a lot of information. But how do we use it in a way that is that gets attention but is not sensational, that ranks them but it's not unfair? So this is a conversation that we have internally all the time. We do not do ground truthing, but we consult a lot of experts and people who work with the system at all levels, not just at the grassroots level, not just at the high policy level. And that's how we have come up with a methodology which so far has been fine. Going forward, we would like to touch on qualitative issues, but we have made a beginning using quantitative data to take the lens of supply. I think there was a lot of discussion on a systems approach. So we have taken a systems approach to say, does your system even have the capacity? Many years ago, we used to talk about pupil to teacher ratio. We used to talk about patient to doctor ratio. And if we really believe that justice is an essential service, which it is clearly, I mean, just 2 days ago, there was a news item where a person was trying to immolate himself in front of a police station. He is an unemployed postgraduate. who bought a e-rickshaw on loan. That e-rickshaw was stolen. He went to the police, who did not give him a hearing, as usual. And after repeated attempts, he was finally so frustrated, he was probably so financially insecure, that he could only draw attention by doing this self-immolation act in front of the police station. So justice denied or justice just not available leads to real-life consequences. And how can we bring that kind of a, for example, story into a report like IJR through data, both quantitative and qualitative, is a challenge. But it does give you a zoomable view. So we start from the national level, and right now we are able to go up to the state level. We will go to the city level, we want to go to the district level, but you can zoom out and you can cover human resources, their diversity, infrastructure, workloads, trends, and budgets. And it is a zooming, zoom out view. I think other speakers in the course of the day will also talk about and reflect on how data can be used. But IGR is a beginning, and it has been possible because we've had the support of many people in this room in one way or another, some more active, others less. But this is all about making access to justice a public demand. It is not happened through judges. It has not happened through reformers within the system. It has not happened through law students who are not even, by the way, taught about what the status of their future workplace is, what the challenges are. So it is only by disseminating this information in regional languages in a simple way, yet not compromising on the nuances, that we can somehow make this slowly a public conversation. So I'll stop here, Anup. Yeah?
Yeah. Thank you, Valay. And I think the big takeaway from me on the challenge was that this challenging mix of reliable and unreliable data in the system, and what lessons can then be learned. To what extent should we rely on that mix and to learn lessons about the system, the zoom out lessons about the system, the challenges for that zoom out perspective, if we are saying that we are relying on the diversity of data in terms of its reliability or official, unofficial, or even the kinds of data, to what extent can we have these zoom out lessons, or are we then better off just not zooming out at all and then saying, let's learn only the lessons from the reliable source of data, but just perspectives on that. Now we'll move to Professor Vijay Raghavan to say that how do we look at these issues of data in the context of prisons? What is it that available data tells us? To what extent is that reliable? And what doesn't existing data tell us about prisons that we absolutely need to know? So Professor Raghavan, over to you. Clearly, we underestimated the number of people coming back. Right? Thank you. It's a good problem to have. May I request the students if you see participants coming in, just to offer your seats.
Here. Yeah, okay. Okay. So first of all, thank you for asking me to share my views. I'm going to look at the kind of challenges that one faces while working with the prison population in terms of access to data Because of the simple reason that if you want to work with a person, you need some information about that person. How easily is that information available? Where are the sources for that information? And where is it that there are problems with regard to data verification, accuracy, and including access? I want to start with, three cases. Just happens to be that all these three cases are cases of women prisoners, which will just give you a little bit of a snapshot into the kind of issues and problems that we face. Names are changed, protect their confidentiality. This was a woman. It just so happened that there was a warrant received by the prison authorities to produce a particular person by a name X for a court date, for a court hearing. Now, the prison authorities sent this woman because she had that name. When she was produced in court, the judge said, I had asked for a man. How is this woman produced before me? So it just so happened that there was a man and a woman with the same name, the first name. She was sent back to prison. Then the question started, what are the case details of this woman? We were working through prayas in that particular prison at that point. So we said, okay, let's find out. And her records were not available. Then the only data point that could be recovered was that she had recently been sent from Thane Mental Hospital saying that she is fit to stand trial. Then we went to Thane Mental Hospital and found out that she was arrested 14 years ago in a case of female infanticide. And she was found to be mentally disturbed and sent away to Thane Mental Hospital. And she stayed in Thane Mental Hospital for 14 years. And suddenly the prison authorities decided, the mental health hospital authorities decided that now she's fit to stand trial. And therefore she can be sent back to prison. And she used to suffer from epileptic fits. And so this was a new thing for us. We then went to the sessions court where, trying to find out, we went and met the principal judge, explained to him about this case, and said, can we get help to find out her case papers? So he was very kind, and he's allotted one peon and said, you go to the record section and search for the file. This was way back in '93, so there was no digitization, no e-courts, nothing at that point of time. And it took us 2 days, but we did find her case papers. It was in a file in all those piles of papers. And then we realized that she had been arrested in a case of murder of her own child. She would not speak. She was, she had become deaf, mute in terms of because of her epileptic fits or whatever. So there was no way to find out what had actually happened. And then from her charge sheet, etc., we were able to find an address, which was, she was living on the footpath in one of the construction sites in one of the suburbs of Mumbai with her husband. That is what was mentioned. So we went to that place. So obviously there was nobody there. Then we filed a writ in the Bombay High Court saying that she should be discharged. The Bombay High Court, instead of discharging her, released her on personal bond with a condition that she would be kept in a rehabilitation home. We approached a rehabilitation home for mentally disturbed people. Fortunately, it was there in Mumbai. They agreed to keep her, and she continues to live in that home. And the case has recently, about a couple of years back, a notice was served to the home asking her to be produced for trial. And then again, the doctors there certified that she's not mentally fit, and then the case was discharged. This is one case. This is another case of a woman. This happened during COVID. Unfortunately, this case has received a lot of attention and it's there all out in the public media. This was a girl who used to work in a food delivery app service. She had parked her bike at some place where it was not supposed to be parked. And then she got into an altercation with the traffic cop. And they really had it out in terms of, disagreements with each other, to say it politely. And that led to the police filing cases under Section 353, which is assault on a public servant, 393, which is robbery, 294, which is obscene acts or words, and 506 and 504, criminal intimidation and breach of peace. Such serious cases were put on her. Within a month, she was granted bail of 25,000, but because of COVID and also because she had relationship issues with her father, he did not come forward to bail her out. She was living with her on her own, and she had got married and somewhere else, etc. We met her because remember that was COVID time, so access was restricted. We met her in February 2020, and then we started following up the case. We came to know that police had filed the charge sheet within 60 days, and the Metropolitan Magistrates Court had granted her bail. But because it was a Sessions tribal matter, the matter was referred to a Sessions court. Because bail had already been granted, therefore we then convinced the father to come forward and stand surety for her. But when we went to find papers, her papers could not be found. They could not be found in the Sessions court, they could not be found in the MM court. Then it got reported in the media. When it got reported in the media, it became a big issue. The High Court asked the Sessions Court principal judge to find out the papers within a day. He said, this matter is not acceptable. And then they found the papers. And after they found the papers, she was bailed out, and the magistrate and the Sessions judge in this case gave her cash bail. We arranged an NGO which will pay her cash bail, and she was out. So that's another story. The third and the last one is about a woman who suddenly, the Baikala jail receives a letter from the Thane Mental Hospital saying this woman who has been in our custody since 1998 is now fit to stand trial, please take her back. Now, Baikala jail did not have women prisoners in 1998. The women's section used to be in Arthur Road prison. So Baikala jail said, we have no records of this person in our prison records. So we should check with Arthur Road. So our social workers then went to Arthur Road and they checked with the Arthur Road authorities, and they were able to find some documentary evidence that this woman really was there, admitted to by Arthur Road Prison Women's Section in 1998 under the charges of kidnapping of a child. So then finally, after a lot of back and forth, we went to the Thane Mental Hospital asking them to allow us to meet her, to just see her condition, because whether if she has to be moved out into a shelter home, they will require some assurance that she is not violent or she's not aggressive and things of that sort. The Thane Mental Hospital people said, you get a letter from the prison authorities, only then we'll allow you to meet her. So we realized that that's also going to take some time. So therefore, we requested the prison superintendent, and he, being a good officer, immediately complied. He sent a letter to the court saying that she has been in prison, in court custody since 98, therefore she should be immediately, the case should be discharged. And the magistrate heard that matter, and he discharged her under Section 417 of the Mental Health Act 1987. Unfortunately, the magistrate doesn't know that the Mental Health Care Act has been 2017 Act has come into place, but nevertheless, we were happy that he discharged her. There were words used in the order like lunatic women and things like that, but let that go. Today, she lives in the general ward of Thane Mental Hospital because she does not have any family to take care of her. 10 more minutes, okay. So, by highlighting through these three cases, I just wanted to bring before your notice what are the challenges that social workers and active lawyers face in accessing data when it comes to criminal justice. Now, where does the data trail start? The data trail in prison starts from the point a person is transferred from police custody to judicial custody through a remand warrant. Once the remand warrant comes into the prison, there is a custody card which is prepared for each prisoner, which gives the details of the person who has been brought in, and the person gets an under trial number. So this under trial number is the most important piece of information, because all the data around prisons of a prisoner is around this under trial number. There are under trial registers in which the under trial numbers details are mentioned, which police station, which court, what sections, when was the date of arrest, what is the date of judicial custody, residence, age, if bail has been granted, whether there is personal property that is, any personal property with which the person has come in, like a watch or a gold chain or some cash or some identity cards. All of that goes into a separate register, which is called the property register, and then that is stored and kept, and at the time of release, that everything is returned back to the person. Next date in court, etc., etc. Now, the veracity of this data sometimes needs to be checked, because it is based on whatever information is mentioned in the remand warrant. And we have found often the two pieces of information which are usually incorrect. One is the address, because most people don't want to give the correct address, so they will give some very vague address, which will be difficult to, actually if you go and locate that house, it will be difficult to go only based on that address which is mentioned in the under trial register. And age is often a problem. In fact, many times in the case of juveniles, the police deliberately increase the age from 17 to 18 or 19, etc., so that they don't have to go through the rigmarole of having to go before the juvenile justice system. They would much prefer, remanding the person to the adult system. And sometimes because the offense is serious, they feel, why should this person be put into the juvenile justice system? Let that person go to the adult system. At least kuch time to rahega andar. Fir wo usko bail milega. Baat ki baat hai. So age is often a suspect data that we find in these records. All subsequent details regarding the future hearings of the case is entered into something called the court diary. So if you want to know when is the next date of a person who has been arrested and who is currently in jail, you have to know the under trial number and you should know the court diary. So court diary se pata chal jayega under trial number ke hisab se ki uska next court date kab hai. Now what are the gaps in data? The name and contact details of the lawyers are usually not available anywhere, as well as if it is available, it is not accurate. The e-court app, which is a new development, does not always reflect the case status until the charge sheet is filed. All the details are correctly entered into the e-court app after the charge sheet is filed. So if it's a remand period going on, and that can go up to 1 month to 3 months depending on the offense, you may not get all the accurate out. There is something called the Roznama, which is otherwise called the order sheet, where on a piece of paper, the magistrate writes in brief everything that took place on that court date. Whether bail was applied for, who appeared in the matter, what was the decision taken, all those details are put in the Roznama. Now the Roznama is the most important document as far as court is concerned, because if you have a look at the Roznama, you'll know what is going on in the case. Very often the Roznama is not fully, properly written by the magistrate because of the pressure of workload on him or her. Secondly, the advocates and lawyers, they need to have free access to the prison in terms of being able to meet the prisoner, and very often it is not such an easy exercise for them. Timings are mentioned in such a way. In Pune, there was a PIL that was filed by the some lawyer saying that they had given timings of afternoon for lawyers to come and meet their clients, and that was not a time when lawyers can go because they are in court at that time. They had also put some other kinds of very silly kind of rules which was making. So anyway, the court passed an order saying all this needs to be changed. Okay, fine. So there should be an effort to make sure that lawyers are able to get easy access either through video conferencing or through telephone. The facility exists, but often it doesn't work so well, because even if there's a phone call, the person there says quickly, make it fast, things of that sort. Now, with regard to convicts, there's another issue. Most convicts who have been served life imprisonment, they have filed appeals in the High Court. They have no clue what is happening to their case in the High Court, unless they have a family member or a good lawyer who's representing them. If it's a legal aid matter, it goes to the High Court Legal Services Committee, not to the DLSA, and the High Court Legal Services Committee has no system of giving feedback to the prisoner that in your case, this is the situation, you have been appointed a lawyer, etc., etc. So this prisoner has no clue. They know मेरा appeal हो गया है, लेकिन 4 साल हो गया, अभी तक कुछ नहीं हुआ. But actually, if you go to find out, the appeal may not even have been admitted, because we all know what is the backlog of appeals in the high courts. And the second important thing with regard to convicts is they don't have accurate information about how much time of their sentence is left. Because it's a very complicated exercise. They get remissions every month. Then they are entitled to parole. They are entitled to furlough. They are entitled to be transferred to the open prison after they complete a certain part of the sentence. But they don't know exactly the eligibility of these things, because the data is not made available. They calculate on their own, and then they request the prison authorities, "Saab, mera application dalo," all of that. So there should be a system where this information is easily available to every convict. There should be an e-kiosk or something of that sort. Now, coming to the last, I'll take maybe a little more than 5 minutes. Just to come to this.
3 minutes.
Okay, 3 minutes more. Yeah. So what is the way forward? I have thought of some ideas, which of course is not my own. It is a product of our team which is working in prisons. The e-prisons should flag when an under trial prisoner has completed 3 months, 6 months, 1 year, 2 years, etc. When the prisoner has completed 1/3, when the prisoner has completed half. So this is very easy. Actually, it can be done. And I'm told that it is being done, but I don't see much evidence of that. Also, the e-prisons will have record of people who have been arrested before and have come into prison. That could be mentioned, because yesterday we were talking about how bail, it becomes an important data point. When prosecution asks for more time and things of that sort. So this could be another piece of information that could be asked. Details about the lawyer and the status of the case should be mentioned in the e-courts, not always done. Roznama should mention all the details of the court orders, and access to lawyers should be there. Medical records can be digitized and made available to the judge, because very often medical bail depends on the doctor being called and giving all the proof, and this could easily be done if the records are digitized, made available only to the court if required. There should be a system of alerting pendency of bail compliance within the software, that if bail has been granted, how much time has gone and the person is still in bail. A roster of jail visiting lawyers should be there. Doctors, NGOs should be displayed across in all barracks, that these are the people who are coming to your prison for supporting you. Another suggestion we have made, not implemented, is this electronic tagging of files, RFID, for all case papers in courts, because finding case papers in courts is a huge problem. So if RFID is done, then easily the court papers can be traced. Setting up e-kiosks for court dates, status of case, bail, appeal, etc. can be done. And digitized information for matters related to period of sentence left, eligibility for parole, furlough, transfer to open prison, etc. I stop here. Thank you.
Thanks, Vijay. And while we download Pooja's presentation, I think prisons present a particular challenge, because that dichotomy between what the state is tracking and what the state is interested in tracking versus what needs to be tracked for other purposes, I think appears quite clearly, right? And I think both Prayas and the Federal College of Policy
Slides you need for
Slide is only for documents.
we were
It
told
can be there, so I would need to.
we were interested in a very basic information as to what is COP. Everybody knows that there's an under trial problem. There's
Are you sure?
76%
Close it and put your machine on top of it.
population under
Then
trial.
you do
But beneath that layer, we're able to say very
Slide
well,
me, I
what is causing that population?
That's very clever.
Is it that bail is not being applied for? That under trial prisoners are not applying for bail? Is it that bail is being applied for and bail is being denied by judges? So in that sense, is it a judiciary problem that they have a very regressive approach to bail? Or is it that bail is applied for, bail is granted, but bail conditions cannot be complied with? It has to be one of these three, right? And the system is incapable of telling us which of these three is it. What, like in Pune Central Prison, what is the proportion of each of these three, right? It's not because the system does not want to tell us, right? Very recently, they said, okay, if there is a way for you to figure it out, right? Here is all the data, here is all the access to the prisons. It's just that the only way to do it would be to do a full-scale survey of Baikala or Arthur Road or Nagpur Central Prison, is to do that full-scale survey. It's not that the prison is saying, oh, I won't allow you to do it, or I don't want to do it, or I'm not interested in finding out. The system, going back to what Karthik was saying, sorry, this is on.
Yeah.
Yeah. So the system was just not capable. He's saying, who's going to do this survey? If I designate 5 people or 10 people from the prison staff to do this survey, an already short-staffed prison for essential services of the prison, for 1 week they are not going to be able to sit and do this survey, let alone how you train those people to do that survey. Again, going back to what Mahesh was talking yesterday, right? Even if you have that, who's going to do this? Are they? So the point is that, and I'm sure Pooja will allude to it in some way, that there is something to reflect on the things on which data does exist and the things on which data does not exist, and which the processes are designed to produce data and which processes are not there to produce data of different kinds. In that choice, it does not seem like a deliberate choice, and whatever is driving what processes we have and what data gets generated by that process itself reflects a certain kind of prioritization, an unstated prioritization of data. So, yeah.
Thank you.
Yeah. So, Pooja, over to you.
Thank you. Thank you for having me. I'm an anthropologist and a political scientist, and I always need a lot of assistance in thinking legally. And much of my interest in policing has developed from thinking the sociology of law and bringing research methods into conversation. Now, this is, I'm going to just very briefly show you these slides. In some ways, I'm making a move very different from Valay, in the sense that I want to propose that the disaggregatedness of data needn't just be confined to thinking data is in a disaggregated manner, but I'm wondering whether it might actually be possible for us to say, at least tentatively, that the state itself is disaggregated. And if it is, then what conception of a state become available to us? But so these were some. This is part of an RTI that I had filed. This is on Delhi police, and this is really a very, very small section of the work that I do, which is on. नहीं चाहिए वो, उसको ऊपर नीचे करना है. Which is actually on the special police units for women and children. So this is a very small section of it. I just needed to think through what I felt would be a very controversial argument, but I want to persevere with it and lay it out in front of you to see, to see what you think about it. And so these are, these are queries, and this is the kind of data I got. This is under the Prevention of Corruption Act. This is only for 8 years because I had data till 2015, and I was just updating it for a chapter. I can, scroll. We can come back to this data, but really, sort of, I'm wondering whether data can be mobilized in service of a much more philosophical discussion. I think that's what. So, from a very, very small sample size, I want to be able to raise today a question that I think goes to the heart of Article 33. So quite the opposite of what I think people have done, which is, so head constables, of course, will always be, head constables and constables will always be a very large section for the simple reason that they form the majority of police forces. I mean, majority of personnel in the police forces. So it's 282 for Delhi police for 8 years. And then this is the data that I was interested in. But I thought, why ask only for the special police unit? Why not ask for the whole of Delhi? And of course, one RTI became 48. On the right, of course, are those that either did not respond or didn't give adequate data. We can see that this data, comparison to this, 3,452, is about 12 times. This is under Delhi police personnel. These are punishment rules which work on preponderance of probabilities. And because they form part of service files, they will not be accessible to us. So in some senses, we'll have to think about what do we do with thinking data that is unlikely to come our way in any way, except somewhat accidentally. This is just organization of the same along ranks, and of course, 84 had to be deducted because it didn't give the data rank-wise. I can loop back to this. Now, what is, of course, not clear here is in how many cases 197 permissions were tied to corruption cases. It is, or what might be the relationship of 197 with the Prevention of Corruption Act, and in what kinds of 197 CRPC cases were other provisions used, and what relationship, therefore, emerges between the guidelines of the Central Vigilance Commission and the 197 provision with respect to police officials. I don't take that up. I also don't have this data. This is merely this is just speculation. I mean, I'm guessing that these are the kinds of questions I might want to follow a little later, but these are relationships I'm not drawing on today. So the provocation for today's paper developed over the last decade from an accidental access to a set of files containing internal orders, notices, show cause notices, censure and reprimands, details of minor punishments at the special unit, where I conducted fieldwork from 2011 to 14, then 16, and intermittently later on. That these documents would be about internal ordering of a police institution is, of course, a given. And in an earlier articulation, I had said that if we think bureaucracies through policing, then we are confronted with a picture of a heightened individuatedness in accountability internally, which exists, of course, in some tension with Section 197 of the CRPC. The tension here is that it is usually said that 197 permissions are not easy to get against officials, but it is often not clear for which provisions of the IPC are we looking for those permissions. In any way, departmental proceedings don't need that. Contrary then to, say, scholars of bureaucracies like Matthew Hull, that bureaucracies are designed for corporate or collective accountability, I think collective responsibility that actually leads to diminishing of individuated accountability. I continue to contend that in policing bureaucracies, it appears that there is no erasure or masking of individuated accountability all the way down. A set of orders, for instance, emphasized that files needed to be marked to IOs to establish responsibility because a file without an IO did not exist. And nobody could be held responsible for it. So a name needed to be attached. Or show cause notices that pinned personal responsibility on officials. Analyzing these internal communications took me to the archive of the Central Administrative Tribunal, thereafter High Court if they were brought up, or even the Supreme Court, of which the very tiny fraction, and to create an inventory of cases where the fate of punishments awarded under the Delhi Police Punishments and Appeals Rules, 1980, is litigated. So in some senses, I'm making these internal moves. That is to say that I want to put forward the idea of examining jurisprudence of acts that govern bureaucracies like police internally. I've not yet made this into a research project, but at this point, my intention was to bring litigation into conversation with documents in my file to understand the nature of disputes in the context of departmental proceedings that are based on preponderance of probabilities, where the court usually do not reappraise or re-examine evidence, but there have been instances where judicial review has been allowed, especially when inquiries were not supported by evidence. I will loop back to preponderance of probabilities and the nature of disputes in just a bit. These are not available publicly, like I said, and because they are part of our service files, I would imagine that accessing them is going to be out of the question, except in this form. A perusal of punishment rules took me then further back to the 1966 Restriction of Rights Act for Police Forces and Intelligence Organizations Restriction of Rights Act 1985. Again, we don't know much about what their jurisprudence has been like. I have not set it up as a research problem just yet. Since both these acts flow from the logic of Article 33, which is limitation or abrogation of fundamental rights in cases of, in forces and public order forces and so on and so forth, it was then the jurisprudence of Article 33 that I became deeply invested in. I was not ready for the surprise, and at least till date, I have been unable to find a single scholarly article on either Article 33 in its original form or Article 33 as it stands after the 50th Amendment in 1984. The intelligence organizations and telecommunication systems were added to Article 33 by the 50th Amendment, obviously with the language of, with the provisions of 33 being towards proper discharge of duties and to maintain discipline. The difference in the police forces and intelligence acts is that in the intelligence forces, in the Intelligence Act 85, these offenses are cognizable. The relationship between Article 33 and 34, particularly martial law, needs greater scholarly attention, but I think that is for another day because it's not clear what martial law, I think Constitution does not define martial law, but I could be wrong on this, and I'm happy to be corrected. It needs to be emphasized that the history of the 1966 Act is tied to protests by police forces, following which there was a reorganization in the service, and with reduction in service hours and so on and so forth. Right to unionize, however, was not granted, and police leaders were put under preventive detention for 17 months. India saw some more mobilizations in 73, 79, 82. 86 is when courts had actually disallowed non-gazetted officials of the Delhi police to form a organization. The last such attempt, like I said, was in 86. The issue of unionization and working conditions, of course, goes back to 1920s, with the colonial state first allowing and then withdrawing all recognition from police associations in the context of a generalized fear about labor militancy. The question of police persons' vulnerability, and I use the word vulnerability with some caution. I'm aware of how I can land very, very wrongly by using that word. And the consequent demand for unionization in India springs not from newer forms of criminalization of society and suspicion, directed at the public as you see, let's say, in the United States. Rather, this issue has to be placed, in my opinion, adjacent to the precarious relationship police officials share with the state that disallows them any political agency as workers and requires work-related matters, including penalties and punishments, to be raised only and only as individual and administratively judicialized grievances and not as political claims. Insofar as collective mobilizations among the police are scuttled, I became interested in thinking whether there were alternative sites. Therefore, CAT. Stemming from this, taking on the state as an adversary, I asked myself, or I was compelled to raise this question about how do singularity of cases pursued by police officials articulate institutional injustice, and what kind of a political subject emerges from these archives. And finally, how might critical theory, for it is still to do this work, engage connections between inhabiting police bureaucracy and its propensity for inflicting violence? I, of course, do not mean for this to be a categorical or a straightforward relation, or for that matter, an attempt at explaining away violence. Rather, it is to ask if we miss something crucial in our analysis of police violence when our attention remains on conflating their political violence with political subjectivity. So Rana Ayoub's work comes to mind. She has a little section on this, but I'll take that in the questions. The crisis that is police's violence eclipses the other, the internal interrogation of police bureaucracy, except in public administrative measures. So for instance, if we look at a little attempt by women police officials with respect to holding national women police conferences from 2002 to 2000, up till now, there was a reprimand given to them in 2016 by the BPRND for focusing only and only on functional efficiency and not raising any political claims, because for that they would have to come back to the MHA. So since then, of course, they've only been raising issues around we need more toilets and so on and so forth. Right? Whereas otherwise, they were making political claims of representation and so on and so forth. Politicization of the police is very well documented and understood, but what concerns me here is the complete othering, the assumption that no thought needs to be expended in thinking emancipatory politics in regulatory environments that compel depoliticization of personnel through rules. Therefore, the language of reform that the MHA uses and how we do not actually raise questions of democratizing policing internally. And yet officials litigating against departmental proceedings and punishments meted out to them provide an important insight into the political, but moving, shifting, and unstable relationship that they have with the state in the absence of any avenue of formal politics that could facilitate solidarity, however temporary. Therefore, it is amid ephemeral political mobilizations and solitary challenges to the state authority, along with, I suppose, an undemocratic, sexist, casteist, hierarchized police spaces that these subjectivities form. In other words, therefore, I become much more interested in how stable inheritances of bureaucratic spaces comes apart internally if we just shift our focus a little bit. And it's at this level that I felt the need to combine method that probably yields less certainty and more depth. And then this brings me back to 33. The jurisprudence on 33 concentrates on 14, 19, 15. And it is really sort of around 2 or 3 issues. First is whether the parliament is the appropriate authority, or whether this power can be given, that is the power of limitation and abrogation, can be given to some other authority. The second is towards adumbration of fundamental rights and its limitation and the extent of its limitation. And the third is, again, very interestingly, by women in the army, bringing 16 into conversation with 33. in a more conceptual move. So again, to draw attention to people in the forces where we actually don't know much, but we also assume that they are not political. In making a more conceptual move, I want to draw attention to this section, and I think this is where I want to take that philosophical leap, which is, how do we think 33 as proper discharge of duties and maintenance of discipline if we keep it adjacent to right to associate? I wonder whether discipline and discharge of duties can be said to mean the same thing in the context of the armed forces and public order forces like the police. Then again, I have wondered whether discipline could become so reified a given that it obviates the need for interrogation or evaluation. I wonder again what the relationship is between indiscipline and sociality, and discipline and individuatedness. That is to ask if atomization is a necessary condition for discipline. Might I even say compliance? Might I say compliance even with absurd orders? If individuatedness is an important generative condition for discipline and enforcing compliance, particularly in the context of public employment being a life-changing resource, what might be the connection between preponderance of probabilities in disciplinary proceedings if we make it sit adjacent to discipline that mandates non-associatedness? And here I think Richard Wexman's work on genocide, I'm not implying we are genocidal, I want to use that only and only as a heuristic. But his work on genocide is very, very helpful because he draws attention precisely to forms of life of minor subordinates who could be declined their forms of life in service of discipline. Insofar as there is no predictiveness that stems from an interiority or a pathology, he argues that obedience was only the result of an ordering authority's legitimacy. However, insofar as I was only following orders may be interpreted with scorn, it still does not explain or interrogate the conditions of discipline that enjoin order following, especially in the context, I might add, of public employment being a scarce resource. Reckman insists, and there has to be a deep focus on the quotidian reality of a functionary of course, he's looking at genocidal bureaucracy, but he's also more generally looking at, let's say, the German police. And this is where I think he makes, in some senses, a very interesting move. He says mass atrocity deserves to be thought of as a total social fact, following Durkheim and Mauss, and cannot be reduced to the sum of consciousnesses of those who carry it out. Reckman, just 2 minutes. Reckman, of course, says that people regularly disobey. Within the context of his work, he says, and people who disobey either leave or are really sort of lying at the bottom of the Mediterranean. If I must pose a question in the language of reform, that humble, small-scale, maybe even rubbish data enables, by taking backward steps, it would be then to think of the possibility of imagining criminal justice reform that is oriented towards teaching evaluation of and disobedience towards absurd orders or problematic orders and compliance more generally. In litigating officials, I see a potential, but I'm not sure how that might be harnessed, given restrictions of one kind or another that flow out of 33, but we need to, I think, examine restrictive acts, insofar as they all scaffold atomized officials. Then again, I want to remind ourselves how implicated we all remain in statist visions, primarily because, again, I think I would just end with this, that I wonder what kind of conceit is at play that Article 33 has been so undeserving of the attention of constitutional scholars. Are we, is this our liberal conceit that we are happy with some abrogation without quite working out how discipline remains tied to asociality, how it remains tied to non-associatedness. And we can, I think I'll stop here. I'll just, so.
Thank you, Pooja. And as somebody who teaches constitutional law, I am guilty of what you suggest, that in the rush to finish constitutional law syllabus, 33 does suffer in that sense.
That's sweet.
Yeah. So no, in the sense that I mean, for benefit of everyone who might not be familiar, what 33 is, it is basically says that all fundamental rights that are available to everyone else is not available like that for certain kinds of public employees, right? And that has led to a whole host of consequences, and completely agree that the jurisprudence is far less developed, far less critiqued in constitutional scholarship. And thank you, Pooja, for directing attention to something that does not get the kind of attention in terms of the internal democratization of something like the police force and what individual litigation might mean. And in another context, we've spoken about CAT litigation, the Central Administrative Tribunal litigation, and what that might signify, and how to assess disobedience within forces like that. So what we'll do now is we'll take comments and questions, and again, what I said yesterday continues. Please don't feel obligated to ask questions or frame questions. Feel free to comment, and I think this is going to be a session where we're going to have that kind of breadth of perspective coming from all of you, because we're interested in what should we understand as the limitations, and I'm sure working in your different contexts, you've encountered these limitations. So comments welcome on what are these limitations, the descriptions of these limitations, but also equally, what are the consequences of these limitations of this official criminal justice data, right? So would be very interested in those breadth of perspective. What we'll do is we'll have one set of comments and questions for 15 or 20 minutes now, break for tea for about 10-15 minutes, and have another full hour of comments in the lead up to lunch. So that's the outlay now. So even if you don't get a chance in this first 15-20 minutes, be rest assured we have another hour once we come back for your comments and thoughts. Yeah, so yes, okay, too many hands. Okay, start. Murli had his hand up first. Karthik and then Tasneem. We'll come back. Yeah, and if you can just keep the comments crisp and questions quick so that everybody has a chance to pitch in. Yes.
Yeah. Quickly.
Introductions again, please, because people,
I'm Murli Karnam. I work with Nalsar University of Law, Hyderabad. Yes, we have to work with the data, whatever is available, because we can't replace the state, because it has huge human power to collect the data. Both CII and PSI, that is crimes in India, and also prison statistics in India, both of them published by National Crime Records Bureau. In my view, the CIA collects data throughout the year. Every arrest, every FIR is reflected in the CIA. It looks more reliable data than PSI. That's one. Secondly, PSI is a data captured on 30th December of every year. It doesn't reflect at all how many people are arrested throughout the year. But before going on to the reliability of the data, I think what constitutes custody is yet to be practically defined, because if some accused is asked to come to police station and remain there for 1 week without registering a FIR, do we consider it as a custody or not? because that is not reflected in the entire data. Okay, after filing FIR only this data is there. Now, I will only give two examples on how to understand the data. One is, for instance, under preventive detention. CIA in 2022 says, including under 107 and 110 and also under all preventive detention laws, India has arrested 95,000 people, 95 lakh people, of which 65 lakh people were released within 24 hours. Rest of them were there from 3 months to 6 months to 1 year. It is there in the CIA. But whereas the PSI, that is prison statistics in India, says the people who are arrested under NDPS, preventive detention laws, the data it reflects is 4,300. Does it have any resemblance? Just 4,000, that's one day. If you calculate for the entire year also, it comes around 30,000, that's all, in prison data. So, these are two different kinds of data. Therefore, we need to understand. This number increased from 2019 to now. In 2019, 70 lakh people were arrested under preventive detention. In 2002, it is 95 lakh. If it is telling us something, we need to understand the nature of the regime that we are experiencing. This one thing. The second thing is, I'll give you another example. When something becomes a data, from the day of FIR, and then custody, and then bail, and then release, conviction, punishment, when what becomes data is something very, very important we have to understand. That is not being understood at all. I tell you a very simple example. In 2022, 1,995 people died in the prisons, of which 1,665 are claimed as natural deaths. How did the government or the prison officers who supplied this data claim this is a natural death? Is it after establishment of judicial inquiry under 176(1)(a) of CRPC or under 195 of BNSS that something becomes a natural? Actually, Justice Madan Lokur at one point I asked this, but he did not stretch it beyond a point. He said, if somebody dies in the prison due to lack of timely medical attention, would you consider it as a natural death or unnatural death? In order to lessen the magnitude of the problem, they have also done something in 2021. That is, a new category is introduced in the natural death category. That is called for unknown reasons. Out of 1,665 natural deaths, 500 come under the category called unknown reasons or other reasons. Still you claim it a natural death. How do you claim it a natural death if you don't know the cause of the death? So data needs to be defined according to the principles of law. Whatever, whether after establishing if it is claimed as a natural death, we don't have any reason. Similarly, even in natural deaths, unnatural deaths also, there is a new category called other deaths. It doesn't say what are the reasons for the thing. So this is one thing. And finally, I want to say only one thing. That is
It's one. Yes.
yeah. See, I know I'm also sometimes helping Maya for this justice report. I think 2 years back I have also done some work for her. During the same time, we were involved in some case before Uttarakhand High Court, in which one outgoing IG who was so frustrated with the prison conditions, he has given complete realistic data before the High Court. Because he was very angry with the government. That data doesn't have any resemblance with what is there in the PSI. And myself and Professor Vijay Raghavan, we asked them, because High Court has recorded everything. What they gave the real data doesn't reflect even 1/4 of what is there in the PSI data. So we asked the IG, but your data reflects in PSI completely different. Then they said, PSI publishes whatever we give them. Why would we give them our real picture? So I was quarreling with Maya. If you take the data from PSI on face value, we'll have a lot of problems. We need to be extremely careful. And this kind of, on deaths in the prisons, I've been working for a long time. I'm proposing that one. I referred about that because if we take that data on face value, we will be doing a lot of injustice, for the people who are in custody. Therefore, journalists or research scholars, we need to be extremely careful, point out these things and make them improve the data so that we can make the system more accountable from the perspective of the people instead of trying to reproduce whatever they are saying. Thank you.
I want to respond.
No, ma'am, later. We will come back. We'll come back. Yeah.
All the 3 points.
Yes, we have 1 hour after the tea break. We'll come back. Karthik?
Yeah, thank you. So, I just want to make 3 high-level comments and observations. Again, since I'm an outsider here and trying to build bridges. So I think the first is, first of all, just want to congratulate the IJR for not only doing the reports, but doing these events with universities. Because I think the most important part, going to your first point about salience, is that so the first important point with regard to salience and kind of capacity building in the broader legal community, it feels that the most important thing is, I haven't looked at kind of law school curricula, okay, but my sense is that there is not necessarily something systematic on either kind of just policy as opposed to law, right? I mean, that thinks about things at a systemic level as opposed to at a case level, right? So it goes back to what I was saying yesterday, that most legal training is about justice in the individual case as opposed to systemic level. So if we can kind of work with the consortium of law schools to just make sure that every law program has 1 or 2 courses that are about systems and make the IJR itself mandatory reading in the curriculum. So that I think would be the lowest hanging fruit. Maybe this is happening already. And then related to that is then have 1 course on quantitative method statistics, what we were talking about yesterday, so that then people learn how to kind of, all of these issues that are coming up. So it's not just about the data, but understanding the limitations. I mean, like even when you do rankings, right? The truth is, if you're serious about the standard errors, none of these ranking differences would be significant. So we put them out there to get some public eyes on it, but we know statistically that's actually quite suspect, right? So I think that's one high-level point, right? I don't know if this happens, but if one concrete consequence of this kind of colloquium is starting with a consortium of the top 20 law schools and looking at the curriculum and making sure that these kind of courses are introduced and then developed, and you do that. So that's one piece. Second is then relates to, coming back to data, we can sit and complain about official data, or we can try to kind of fix this. And so, again, to the extent that IJR has many resemblances with Pratham, like of trying to make this issue salient, right? So in the end, what Pratham did was, they said, and that's the slide I showed you yesterday, right? About how inflated, so this issue is there in every sector, okay? So we overstate learning outcomes, we understate malnutrition, so it's there everywhere, okay? So I think it may make sense to kind of then, as part of that course, to have students take up projects where you're starting to do citizen level surveys, crime and victimization surveys. That may not happen at a nationally representative level, but even if you start doing this in small representative samples in 4 cities, 5 cities, wherever the law schools are, that gets you started along at least then saying, here is what I'm hearing from citizens, here is what is in the official data, what does this delta look like? So you start getting some ballpark estimates and making the issue salient, because I think crime reporting is one of the hardest areas where, because better policing can actually make the crime stats go up, because the first thing people do when they feel more confident is report more crime. So it's one of the most perverse situations, right? I mean, even from how do you document national progress when the reporting is so endogenous, okay? So I think that can be a really high leverage kind of, again, I'm thinking about concretely where does one go forward from this colloquium in terms of action items, right? So first is curricula. Second is then, as part of the training, you have practical projects. And again, if you think about how Jean Drèze, trained legions of students who would then kind of just go do field work as part of their projects. And so if you can do this kind of, and this is then the subtle quantitative qualitative balance, right? It will not be representative of the whole country, but even if you take narrower, well-defined geographies, you can be more rigorous in your sampling, like Mahesh was, so the tools exist, the templates exist that can be ported into the curricula and then be made part of practical projects. So, and then the IJR gives you a way to kind of feed that back, because these may not be rigorous enough for fully peer-reviewed papers if it's done on kind of small sample student projects, but if the quality control happens through a coordinated IJR mechanism with a consortium of faculty who are designing the methods and the training, that I think could be a very concrete way of taking this forward, because the official data will not match as far as we can see. And the third point, I think, goes back to this kind of really subtle balance about how kind of the justice community interacts with the state, right? So there is an element of this that is adversarial by construction, because, there is no question that there are power structures that kind of want to hide inconvenient data, right? But the flip side is that even the well-intentioned people in government are fundamentally constrained by capacity, right? So it is, how do you both kind of be critical where warranted, but support, and therefore when you identify a problem, kind of saying, here is the solution. Okay, so the thing with all of my interactions with government officials over the years is everybody will say, yes, this is right, but I don't have the resources to do anything about it, right? So then, if you want to be then part of the solution, thinking about, say, what happened in Kerala, where I think a consortium came together, put together a roadmap and said, let's do this pilot with a bunch of these reforms. So similarly, when you're talking about, what kind of data should be available in the prison system, right? So it shouldn't be that difficult to kind of pilot something and work with kind of, GovTech, civic tech kind of entities to create that kind of app, and find, a few progressive prison officers who are saying, just go implement this. So I think the key part in terms of moving the discourse forward is identifying the solutions, the challenges, but then being kind of entrepreneurial about solutions, and then finding the champions within the system who will take the solutions and run with them. So,
thanks. Thank you. Tasneem? Sorry, I identified the three. I'll come back. We're going to come back for an hour, right? Yeah, Tasneem? Yeah.
My name is Tasneem. My name is Tasneem. I'm an independent legal researcher. I want to talk a little bit about the legitimacy of data. So numbers have a veneer of objectivity, and so they don't really engender questions of legitimacy. But as Valay pointed out, numbers are not data. And so I wanted to encourage us to think a little bit about the issue of legitimacy of data, where legitimacy is conceptualized beyond accuracy, beyond reliability, and speaks to acceptance or trust as a prerequisite to utilization in decision making. And this legitimacy is questioned, or this inquiry of legitimacy is around aspects of who is asking which questions of whom and how. And so there's three aspects here, and I want to draw on the conversations we had yesterday and today. As I see it, this inquiry into legitimacy has kind of three levels. So you have the level of source. What is the source of this data? So as Justice Muralidhar was saying, if it's not pro the government, then somehow there's these conspiracy theories, or this fairly false distinction between official and unofficial data, right? What's the source? The second is the scope of data, which is, is it a large scale, or is it cottage industry, as Mahesh said very derisively? And the third is in terms of interpretation. And this interpretation is both in terms of method and how we publish findings, right? So method being, are we going to use dynamic modeling or efficiency testing, or are we going to engage in meaning making through ethnographies, which is what Swagata tried to do yesterday? Or is it the way we publish findings, right? So do we publish findings to describe a state of affairs, like what the India Justice Report does? Or are we trying to make claims of causation, which is what Karthik and other economists are trying to do? And I believe that this inquiry into legitimacy has to go beyond the critique of the state and become a sort of introspection. And introspection, kind of a call to introspection to all of us who work with data. So instead of focusing so much on reliability and accuracy, which is of course part of this analysis, let's think of it in terms of legitimacy. Is this data legitimate? Perhaps that is a question that we might think of asking ourselves.
Yeah. All right. Thank you. Thank you, Tasneem. I'm going to stop there, and we'll come back for an hour of discussion in about, it's 12:05 now, so at 12:20 we'll come back. If everybody can just step out, have a cup of tea and stretch your legs. I'd request everyone to come back here sharp at 12:20, please. And we'll go on and we'll break for lunch at 1:20. Yes.